Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss legal victories and challenges to your fundamental freedom and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, founder and chairman of Liberty Counsel, explains the latest legal issues all across this country. In the courtrooms of America, Liberty Counsel is winning the battle for your constitutional freedom.
An Arizona public school ends prayer before its normal meetings and instead opts for a moment of silence. Is a moment of silence all that is permissible at these public events? Hi, I'm Matt Staver, founder and chairman of Liberty Counsel. Joining me is Matt Barber. Matt, this particular situation is frustrating because there's been no lawsuit. There's simply been an objection regarding this school opening up its meetings with prayer. And so the school board council ultimately said that they ought to not have prayer, but they should instead open with a moment of silence. Certainly a moment of silence is permissible, no question about it. But the question is that all you can do? Can you only do a moment of silence at these opening events, whether it's school board, city, or county council? And of course, that issue right now is before the U.S. Supreme Court.
It is. The case is the town of Greece v. Galloway in upstate New York, and the courts, once again, the courts have heard prayer cases, public prayer cases on multiple occasions, the Marsh case and others, where clearly the United States Supreme Court has held that in terms of legislative prayer, that it's part of the, quote, fabric of our society, yet it's sad to see when administrations like this surrender to the bullies, and these are bullies we're talking about here, who want to silence any prayer in any kind of public forum. It's really a shame to see them surrender and give in to the bully.
No, it is. And in fact, of course, the Marsh versus Chambers case from the U.S. Supreme Court dealt with the Nebraska legislature, and the question is, could they open that session with prayer? And the Supreme Court, for the first time, and really one of the only times, did a historical analysis of the First Amendment. Very surprised. But when they do that, they come out to the right conclusion. And they basically said that the First Amendment could not be construed to prohibit prayer at these public gatherings, such as these legislative bodies, because prayer predated the First Amendment, and the very first act of the Congress who actually drafted the First Amendment and approved the language of the First Amendment was to vote to have a chaplain paid by the federal treasury open every session with prayer. So if that is the case, how would they draft an amendment that would undermine exactly what they were doing? And so consequently, historically, it's no question, legislative prayer in the state legislators, legislative prayer in the federal Congress is clearly permissible. The question now comes up, well, some people say, but now at the local level, the city, county, or school board, it may be a different story. And a couple of courts have ruled, federal courts of appeal, that it's okay to have that. And then one ruled that it was not okay, and so that issue is before the U.S. Supreme Court.
Matt, we talk a lot about judicial activism. And isn't a part inherent within the notion of judicial activism, the idea of getting away from the original intent and meaning of what we have in the Constitution and adding to that or subtracting from it in order to push a certain ideology? Isn't that what we've seen in terms of haven't the courts over the years gotten so far away from the original intent and meaning of the First Amendment that it's unrecognizable?
Yeah, you get so far away from it that it's unrecognizable. When the Supreme Court does a historical analysis like it did in Marsh versus Chambers, the result is pretty easy. Does the First Amendment prohibit prayer at these legislative bodies? And it's pretty simple. From a historical standpoint, absolutely no. It's not an establishment of religion. They never envisioned it as establishment of religion. Judicial activism begins basically in the late 50s and also particularly in the 60s under the Warren Court, where there were ideologies that these justices had, and they cut themselves free from the actual text and the history and understanding of the Constitution itself. And so consequently, judicial activism begins with these justices not restraining themselves. They just simply vote, and the rest of the country goes along with it as though that is the rule of law.
Well, and in so doing, they've invented a number of tests that they use and that they apply that again weaken the original intent and meaning and strength of the First Amendment and instead push a certain ideology. One of those tests is the Lemon test.
Yeah, the so-called Lemon test. It comes out of a case called Lemon versus Kurtzman, and it's basically a three-part test that's been narrowed down to a two-part test. And essentially is, does this have a predominantly secular purpose? Or does it have a predominantly religious purpose? And then also, does from an observer, would they observe that this endorses Christianity or religion? You know, all of that is just nonsense, because when you look at it in the nativity scene context, a nativity scene with the baby Jesus and Mary and Joseph, the Supreme Court says it's constitutional so long as you have some secular symbols of the holiday. Well, where did they come up with that? I mean, that's just a judicial gloss. And then how many symbols of the holiday do you need to have? You know, Christmas and clearly that is what the law is right now from the Supreme Court. But it just makes no sense with regards to the original understanding. You don't count objects to determine its constitutionality. And you shouldn't have to count somebody's subjective motivation. Did they have a subjective motivation to advance religion, or was there a subjective motivation just simply to be educational in nature and had no advancement of religion in mind? So there's many of these aspects of these tests that the justices have criticized. They say that they're not workable, they're no good. Sometimes they use the test, sometimes they don't use the test. Frankly, in this town of Galloway case, Liberty Counsel filed a brief supporting this prayer at this local event, this local deliberative body, city or county council, and it would also apply to school board as well. But we also argue that the Supreme Court ought to come up with a more historical approach to the First Amendment. That would solve many of the problems. The historical approach would be more consistent with the actual reading of the text and the history of the First Amendment.
Well, the problem is that the judicial activists on the Supreme Court over the years have changed the Establishment Clause from Congress shall make no law respecting an establishment of religion to government in any form shall make no law respecting the endorsement of Christianity. That's basically how the Establishment Clause today is applied.
Yeah, but if you just look at the First Amendment, it applies only to Congress. It doesn't apply to the states.
Right.
It was a restriction on Congress. It was a specific iteration of what the 10th Amendment says. Any rights, any powers not given to the federal government are retained by the states. That was a generic description. First Amendment was a specific description. Congress, you have nothing to do with religion, free exercise, or establishment within the states. That's a state issue. It's up to the state constitutions and the legislators. And then, of course, they changed that and they applied it to the states, which turns it 180 degrees on its head. Instead of preventing Congress from getting involved in the states, it now opened the door for them to do exactly what the First Amendment prevented them to do. And then beyond that, as Justice Story said, one of the early Supreme Court justices, that the First Amendment was designed to encourage Christianity. So far it was not incompatible with the rights of conscience. Then they moved from not only it applies to the states, but it has to basically create almost a level playing field of secularism. And it becomes hostile to the actual protections that it was designed to protect.
Well, it actually now says essentially that Congress or government shall make laws prohibiting the free exercise of religion, which, of course, is a violation of the Free Exercise Clause of the First Amendment. And we've gone from establishment to endorsement.
Yeah, so the good news is that there has been some good cases from the U.S. Supreme Court on the free exercise of religion, coming down with a resounding free exercise opinion, 9-0, which is amazing, rejecting the Obama administration's idea of wanting to limit the free exercise of religion. And hopefully in this case, town of Galloway will also have more clarification and hopefully an original approach to the First Amendment. For more information, go to Liberty Counsel's website and ask for the book by David Barton, Original Intent. I encourage you to read this book. It's a great gift at any time of the year, but it is a great read. It gives you the great foundation that ultimately makes America what it was and what it is now. That's the book by David Barton, Original Intent. There's also the New England Primer. It's a textbook that was used in American public education. Next to the Bible, it was one of the most influential books in American public education up through the early 1900s. For a contribution to Liberty Counsel, we'll send you that as well. And also we have now the 5-part series of the Patriot's Handbook, and we have Israel, the Second Amendment, pastors and churches, we have the Constitution and other documents related to our founding, and we also have religious freedom in public schools. So you can order that series as well. Any contribution that you give to Liberty Counsel in any amount between now and December 31 will be doubled. So we encourage you to use this challenge from a donor to Liberty Counsel to double the contribution, and the impact of your $10 now becomes $20 and your $100 now becomes $200. So you can make a contribution to Liberty Counsel. You don't even have to say that it needs to be the challenge grant. It's automatically going to be a part of that. Go to lc.org.
You have been listening to Faith and Freedom with Liberty Counsel. We hope that we have motivated you to stand up for your faith, family, and freedom. We can accomplish a lot when we work together. Get informed and get involved today. Sign up for our free monthly newsletter, The Liberator. We will send it out to you free of charge. Stay informed with our Liberty Alert email updates. Just click on the website at www.lc.org or call us at 1-800-671-1776. Tune in next time to learn more about your rights right here on Faith and Freedom.